And because now that you have mentioned Trump, I wouldn't want to miss this chance.
It's fanciful thinking, like much of Trump's diatribes these days.
Until they are removed out of our country and back to the country from which they came.
DHS has a lot of room to maneuver within that space. It was guided by a case called Chevron. And the Chevron case said, if the statute is clear, the government has to follow the clear language of the statute. H-4s are stealing U.S. worker jobs. Now, they lost, and it's not surprising to anybody who understands administrative law why they lost.
Hello and welcome to another compelling episode of the Immigration and Jobs Talk Show. I am Rajni Bharara, your host. And before I move ahead, I would quickly like to read out this very important disclaimer. By watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. All right, after this very important disclaimer, welcome back everyone to another compelling episode of Immigration and Jobs Talk Show. I'm your host, Rajni Bharara, and today we are diving into a subject that could reshape the landscape for H-1B visa holders and their families in the United States. If you or someone you know is navigating the complexities of US immigration, especially within the tech sector or other high-skilled industries, this episode is something that you won't want to miss. Recently, the US Court of Appeals made a groundbreaking ruling that upholds the right of H-1B visa holders' spouses to work in the United States, a decision that has garnered widespread attention and sparked significant discussion. But what does this ruling truly mean for H-1B families, American workers, and the broader immigration landscape? To help us unpack these crucial questions, we are thrilled to have with us today one of the foremost experts in immigration litigation, Jonathan Wasden. Jonathan has been at the forefront of landmark cases that have shaped the future of US immigration policy, particularly around H-1B visas. We'll be exploring not only the implications of this recent ruling, but also diving into the broader context of the H-1B litigation and how his firm is leading the charge in defending the rights of visa holders and their families. So without any further ado, let's welcome Jonathan Wasden to Immigration and Jobs Talk Show. Okay, so John, welcome to the show. We are again thrilled to have you back with us today. So how are you doing?
Good. How are you doing?
I'm doing well, fine too. Thank you so much for asking. So, John, now, I would directly like to jump into the questions. And firstly, I would like to know the basic understanding of the ruling. So, my very first question to you is, can you briefly explain the significance of the recent US Court of Appeals ruling that upheld the right of H-1B visa holders' spouses to work in the United States? What do you have to say?
Yeah, so that case was brought by a rabidly anti-immigration group. And it was premised on the idea that H-4s are stealing US worker jobs. Now, they lost, and it's not surprising to anybody who understands administrative law why they lost. The structure of the Immigration and Nationality Act gives a blank check to DHS to determine which aliens, as the term that it uses, are eligible for employment authorization. And because that language is so broadly drafted, DHS has a lot of room to maneuver within that space. And the structure in place at the time was guided by a case called Chevron. And the Chevron case said, if the statute is clear, the government has to follow the clear language of the statute. If the statute is unambiguous or doesn't anticipate all the issues, or is ambiguous rather, and doesn't anticipate all of the issues, then the agency's reasonable interpretation of the statute is going to be binding. And in this case, the statute was wide open. It didn't explicitly say H-4s, but it gave DHS wide discretion to grant the employment authorization to various people. And the court rightly said, it's not unreasonable to say that H-4s can work, especially in light of the fact that just about in every other industrialized country in the world, when you get an employment-based visa, your spouse automatically gets the right to work. And so it wasn't unreasonable in the court's view for DHS to come up with this regulation allowing H-4s to work.
Thank you so much for answering the question, John. And John, how does this ruling fit into the broader context of US immigration law? And how has there been a precedent for similar cases?
So I think it actually built on a prior precedent that dealt with OPT and CPT authorization. The same group tried to attack, the ability of students to work during their post-graduation or educational visa. So, when you look at that, those are dealing with the almost identical issue, which is what is DHS's power to grant authorization for employment. And it's pretty broad. They have a lot of authority to pick and choose who they want to give employment authorization to. In terms of its overall impact on immigration law, probably not that much, because as you look at immigration law, each individual visa category and each individual benefit category has its own statutory language. And the broader that language is drafted, the more power the government's going to have to make rules and regulations to fill in gaps. The more in-depth Congress legislates on an issue, the less freedom that the agency is going to have to create regulations. So, if you look at the H-1B program in particular, the statute governing the H-1B, there's two different provisions in the code. It's this section that's delegated to DHS is very general and very brief and just says that they determine specialty occupation. Then the meat of that H-1B statute is actually in a different section that goes to the Department of Labor. And the Department of Labor's authorities and the rules for the H-1B program are really in that section. And they're expansively drafted out and they're very carefully thought out. And every permutation has been considered in those statutory sections. And so, the government's ability to make rules under that section are severely limited because Congress has covered so many of the bases. So I guess the takeaway is in a visa category, say like an L1 or an EB1C, where the law is very vague, the agency is going to have a lot of discretion on how they determine the outcome of a particular case or a regulation. The more specific the statute is, the less latitude they're going to be given.
And also, I would like to know, John, given your extensive experience in immigration litigation, particularly with H-1B cases, how do you see this ruling impacting the strategies and defenses you may employ in future cases?
So again, this case was decided under the old Chevron structure. And Chevron was a case that said, if a statute is ambiguous, the government's reasonable interpretation must be deferred to by the courts. That's been done away with now, and now the court is given the authority to determine on its own, without deference to the government, whether or not a regulation or a final agency action complies with the statute and whether or not it's reasonable. So the whole landscape of administrative law has been altered as a result of that new decision called Loper-Bright. I think this case, the Save Jobs case, would have been decided the same way, regardless of if it was Chevron or Loper-Bright, because the statute very clearly gives DHS a wide variety with no limitations on who can work. And I don't really see any court ruling otherwise, regardless of the analytical framework that they're employing. So, that case would have turned out the same. So in future cases, it remains to be seen how Loper-Bright is going to impact us. I think it's going to the court and the judge that has the case is going to matter a whole lot more under Loper-Bright than it did ever before under Chevron, because it's the meaning of the law is in the eye of the beholder in each case, and right now that's up to each individual district court judge in the country that has a case land on their desk. So it'll be interesting to watch it develop, because I think there's the very high likelihood that different courts around the country are going to have different answers to the same questions, and how they resolve those differences is going to be fascinating to watch. And it's going to end up, again, with a new Supreme Court decision explaining how to do administrative law.
Thank you again, John, for answering this very important question. Now I would like to talk about a little bit about impact on the technology sector. So, major tech companies have strongly supported the rule allowing the H-1B spouses to work, right? So how critical is this ruling for tech giants like Google, Amazon, and Microsoft?
Yeah, so for those companies, I think the tech industry in general is benefited, but also the medical industries and education are also benefiting from the H-4 right now. There's a crazy number of doctors, dentists, nurses, professors that are all working on the H-4 right now, not just in tech companies. So I think the economy overall benefits greatly from the H-4. The interesting thing to me is the argument against the H-4 is that it's taking U.S. workers' jobs. The H-4 has no restrictions on it, right? You can work at McDonald's if you want to, or you can work as the CEO of Apple if you wanted to, theoretically. And so without those restrictions and without all the rules governing wages that H-1Bs have, what we see is oftentimes the H-4s are making far more in salary because they can negotiate on their own than their H-1 spouses. And so that tells me that in the economy, there is a high demand for their skills. And that high demand for their skills is because we don't have enough workers coming out of US colleges and universities that are qualified for those jobs. And because we are lacking people that can do the jobs, people that are on an H-4 that can become more and more valuable and necessary to the economy.
Absolutely, absolutely. But John, as you mentioned, not just tech sector, but other sectors are also significantly benefiting from this decision. So could this ruling potentially influence hiring practices in other industries as well?
Yeah, I think so. I think, for a while there during the Trump administration, the H-4 was a red flag. You didn't want to deal with it because they were intentionally screwing around with the adjudication process and forcing people out of employment authorization. That's a situation that has been resolved now. And so, H-4s are back into a predictable employee model. And I think they're going to be more and more sought after the more certain their future becomes. And I think this decision made their decision far more certain and far more clear. And that just gives employers and corporations the comfort and security they need to hire people in that situation.
Okay. So, John, also in your practice, have you seen a trend of companies reaching out for legal assistance following such rulings? And how do you advise them to navigate the complexities of these evolving regulations?
So like I referenced earlier, during the Trump administration, when they were intentionally messing around with L2s and H4s and their ability to work, we had a lot of people coming to us. And so we filed a series of cases, and we had two class action cases actually on those issues. And the government settled those cases because they were going to lose. And they changed the way they do things for both L2s and H4s. The L2s were given employment authorization incident to status, meaning they can just work if they have an approved L2. They don't need an EAD. The H4s, certain H4s were given auto extension of their EAD, and the remaining population of H4s were returned back to concurrent processing of their H4 and EAD along with the primary spouse's H1B. So, those victories a few years ago have, really impacted, the employer's comfort and security in hiring H4s and L2s. The uncertainty of whether or not you're going to have this person here in a few months because of USCIS's incompetent processing times is no longer there. And so, people are far more comfortable hiring H4s and L2s. But, since that time, I don't think there's a whole lot of concern that, employers have had in terms of litigation. This case, the Save Jobs case was, the plaintiff in that case was an activist group that is anti-immigration, and the defendant was the US government. And they litigated the case, very well and quite easily. And there really wasn't any involvement from private industry in it because I think it was a foregone conclusion that the plaintiffs were going to lose and the government would win.
And because now that you have mentioned Trump, I wouldn't want to miss this chance. Recently, when I think Trump was giving a speech, he said actually that if he comes to the office, there's going to be a deportation of around 50 to 60 million immigrants. So what's your take on that?
Yeah, the logistics of that kind of blow your mind if you think about what it actually would take. So, Trump says a lot of things. Very few of them are based in fact. And I think this is one that is just so wildly crazy that it's appealing to his base that are anti-immigration and xenophobic, but in reality, it could never happen. Because the Constitution gives everybody certain due process rights. And even if it didn't have due process rights, rounding up 50 million people and getting them out of their country to their home country is a logistical nightmare. And it's not something that can be done just with the sign of an executive order. So it's fanciful thinking, like much of Trump's diatribes these days.
Under my administration, anyone who illegally crosses the border will be detained until they are removed out of our country and back to the country from which they came.
So after you've answered this question, I would like to know a little bit about Wasden Immigration Litigation's role in immigration law. So John, your firm Wasden Immigration Litigation has made a significant impact in the field of immigration law. So can you share some landmark cases that have shaped your approach to litigation, particularly those involving the H-1B program?
Yeah, so the first case we did was challenging a Department of Homeland Security rule that prohibited OPT and CPT students from working for consulting companies. And so they did this rule change without following the law. They just posted it on a website and buried it in there, didn't let anybody know. And so we sued on that, and within 2 weeks, the government reversed course, changed the rules on their website, and the issue went away. The next issue that we started facing was these H-1Bs that were getting one-day approvals or approvals that were granted after the notices or prior to the notices being sent out. So it was already expired upon delivery of the 797. And it was just causing a lot of disruption. And it was based on a new policy memo that required that you have to have a contract for a specific project at the time you file the H-1B. And so basically what they're saying is you have to have a guaranteed work assignment for the duration of the 3 years and prove that you have that for 3 years. in order to get your visa. And the other issue that was popping up started in 2010, which was the Neufeld memo, the employer-employee relationship test, which was explicitly targeting staffing and consulting companies. So we filed suit on that, and both of those issues were resolved. The Neufeld memo was invalidated by the court, and it said the law is clear. This is how you determine a employer-employee relationship. Your convoluted test is not based in the law, and therefore it has to go. And in terms of the guaranteed specific project assignment, the court sided with us and said, the law has in here a provision that says an employer can place an employee in non-productive status for lack of work. And because it has that provision that explicitly allows the employee to not work, your requirement to have proof of a project for 3 years is against the statute. And so all of those things got wiped out. And in almost overnight, what we saw was, H-1B processing times for the form I-129 went from upwards of a year down to a week, and that's without premium processing. So it really did streamline the system, and it made things much easier and much more comprehensible for the public.
Okay. Also, but John, how does your firm differentiate itself in handling high stakes immigration cases, especially when dealing with challenges like the ones posed in this ruling?
Yeah, so we're kind of in a limited space, really. Most of the large firms doing administrative litigation don't know immigration, and if you're going to hire one of those firms, you're going to end up spending them a ridiculous amount of money just to make them smart enough on immigration to do the case. And then on the flip side, you've got the immigration law firms, and the immigration law firms are typically so used to just doing what the government wants just to get an approval that they don't really break it down and analyze and challenge the basic ability of the government to make rules or make decisions. And so a lot of times they just lack the creativity to do it because their mindset is so focused on what do we need to tell our clients to do to get an approval, as opposed to what should the law be. And so there's not a whole lot of people in this space doing this. So it's it's a small market. There's not a lot of differentiation to be done, I guess, because it's just such a niche. What's funny though is when I left the government, I worked at DOJ, and then I went to USCIS. And when I left the government, I wanted to start a practice that was exclusively litigation and not do petition filing. And I talked to dozens of large immigration firms, and they all said the same thing, which is, oh, you can never make a practice of that because nobody's going to have an interest in litigation. And so I started my own thing, and within a month or two proved them quite wrong. But it just shows you that most immigration firms are just not thinking the right way about how to solve these issues. They're just focused on following their business model, getting things processed, getting things approved, and not making significant structural changes to the law.
Okay. All right. Thank you so much again for answering the question, John. I again would like to talk about Wasden Immigration Litigation, but in a while. So now I would like to discuss with you about the legal challenges and the Chevron deference. So, John, the legal challenge from Save Jobs USA argued that the 2015 rule displaced American workers. So why did the court dismiss this argument, and how did the concept of Chevron deference play a role in this decision?
Yeah, so Chevron just says that if the law is unambiguous, you have to follow the clear language of the law. But if it is ambiguous, if it's not explicitly clear, then the government can create a regulation to fill in the gap. And it's going to be upheld as long as it's reasonable. And the courts were required to defer to the government's decision unless it was, explicitly violating the statute. So in the Save Jobs case, the law was very broadly defined, giving the government lots of space to fill in those gaps. And, the court looked at it and said, okay, there's a lot of room here for them to move and make decisions and rulings. They went through the process, they created the rule, and we can't say that it violates the statute, and we can't say that it is, unreasonable. Therefore, the government wins. The Chevron case, again, like we discussed earlier, is, no longer in play. It's been invalidated by the court. It's been overruled. I think this case, the Save Jobs case, would have the same result regardless if it was Chevron or its successor, Loper Bright. It's just such a no-brainer that the government can do this, that it, is somewhat surprising that they actually put together a frivolous lawsuit to challenge it.
Okay. And John, also, how has Wasden Immigration Litigation prepared for potential shifts in legal precedents, especially the changing interpretations of Chevron deference? And what should clients be aware of in these uncertain times?
So right now, what we're focused on is consolidating a lot of the wins that we've had in court and building on those. And really the focus that we're looking at right now is forcing DHS, which is the parent agency of USCIS, to follow the law. And one of those areas that we're really focusing on is getting them to play by the rules when it comes to penalizing or sanctioning people for immigration fraud. They have a tendency to do that in secret, not tell you, wait for you to leave the country. And only when you go for a visa stamp or only when you go to the port of entry to re-enter do you find out that they've ended the fraud finding against you, and you have no chance to defend yourself then. So we're trying to get the focus back on to DHS to say, you have obligations under the law to give notice before you do this, to give an opportunity to respond before you do this, and to give a written decision explaining why you did this so that we can challenge it in court if we disagree. And we're slowly moving the needle on that and holding them responsible. And I think as more courts see it, they'll side with us on that. And what was your second question? Sorry.
So I also wanted to, you to also advise, what should clients be aware of in these uncertain times?
So I think you should always keep an eye on what should the law be, not what is expected by USCIS. If you're focusing on what USCIS wants, then you're just giving in on the core issue of what the law should be. So focus on what makes sense, what it looks like the law says, and when USCIS is doing something that is at odds with that, don't just roll over and give them what they ask for. Push back and fight, because that's the only way that you'll force them to maintain sanity in the system. What we saw for decades in the H-1B program especially was companies and law firms just rolling over and not pushing back on what the law should be. And it led to USCIS making increasingly arbitrary policies and rules because they knew they would never get challenged. In fact, when I worked in the government, I would highlight certain issues that I thought were vulnerable in litigation, and they would say, we don't have to worry about that because nobody's going to sue us. So changing that mindset within the agency makes them a lot more cautious, makes them, work a lot harder before they make policies and rules to make sure that if they do get sued, they won't be, ruled against by the court. So by being aggressive, by, pushing for what you think the law should be, you make the government more responsible and you make them more cautious. And I think the industry, and the country as a whole benefit from the government being more cautious before they do things and actually thinking through their decisions before they pull the trigger.
Wow. Okay. That's a really good advice. But John, does the law and USCIS, does they not go hand in hand? Are they two different?
Very much so. And in fact, USCIS's history in following the law has been very spotty, checkered, maybe gray. So just because USCIS says something doesn't mean it's accurate, doesn't mean that's what the law says.
Wow.
A lot of their, especially when you read their decision letters, a lot of their conclusions are completely not based in law or mischaracterizing the law. And so, just because they have a policy or they have a adjudication trend doesn't mean it's backed up by the law. If they always were backed up by the law, I would not have a job. So the fact that I exist means there's plenty of places where they're screwing up and they're cutting corners.
Wow, that's a big revelation, I would say. All right, thank you so much again for answering the question, John. Now, I would like to talk about, DHS's authority a bit. So, John, how far-reaching is DHS's power when it comes to shaping immigration policy?
So it really depends on which visa category we're talking about.
Okay.
So, some visa categories are very broadly defined in the statute. They're so broad that you don't really know what the standards are. When that happens, say like in an EB1C, the International Executive or Manager visa, or its analog, the L1, there's very few standards in the statute that let you know what is required to get an approval. So USCIS has filled in those gaps through policy and through some regulation and some decisions, some binding decisions. The ability to challenge those decisions in court when they deny an EB1C or an L1, it's very difficult because, my job is easiest when we can point to a clear rule that the government's violated or that they're contradicting, or point to a process that they failed to comply with when making a decision, and then we win. But when there's really no rules to apply, there's nothing for us to point to and say you're doing it wrong. And those broadly defined visa categories are tough. Now, when you look at the Immigration Nationality Act that Congress created, you have some sections that are very short, and then you have some that are very long, where they just go through and they analyze every possible situation, or they explicitly create tests for how to qualify for the benefit. In those visa categories, USCIS's and DHS's ability to make rules and policy are very, very limited because Congress thought through all of the issues already. So, it just really depends on the visa category you're looking at. I think the H-1B is thankfully, a very well thought out program by Congress with a lot of rules that Congress has put into the law. And that really does limit USCIS's ability to mess with people. And that is as long as you're aggressive and you push back against USCIS. If you don't push back, if you don't fight them, they can do whatever they want.
Okay. But also, John, do you think there could be any legislative pushback against DHS's broad authority in the future, particularly from groups advocating for stricter immigration controls?
So, again, the new Loper-Bright decision that came out that overruled Chevron.
Mhm.
It'll be curious to see how that plays out, because that makes every district court judge in the country the decider on what the law says and what the law means. And that creates the possibility that you could have a judge in Texas ruling, for an anti-immigration group on one hand, and a judge in Seattle ruling the exact opposite way on the same issue. And so, how that resolves and how that gets ironed out is going to be interesting to see. I think, as lawyers, we say anytime there's new law, there's new work. I think the, Loper Bright, post-Chevron era is going to create a lot of, litigation and a lot of work for lawyers that are in the administrative law space like me.
Wow. Okay. And again, John, thank you so much for answering the question. Now, I would like to talk about the impact of this ruling on H-1B visa holders and their families, because again, this is something very important. So, John, from a very practical standpoint, how does this ruling impact H-1B visa holders and their families, and what changes might they expect in terms of work opportunities and their overall experience living in the US?
So I think the good thing is it gives them a little bit more security.
Okay.
Now, you look at what a court's going to do now is look at the language of the law, but also look at the purpose of the law.
Mm-hmm.
And for the H-1Bs, the purpose of the law was to increase the number of highly educated, specialty occupation workers in the United States, because we were not creating enough of them domestically to fulfill the needs of the economy. And so coming into the case, a lot of factors are already on your side if the government denies your petition, your visa. So, the law typically is going to be on your side a lot of times. And then even when the law is not exactly clear, the purpose of the statute is going to be on your side. What the government is looking to do by denying your visa petition is exclude a highly qualified, highly educated specialty occupation worker from the workforce.
Mm-hmm.
And that really does go against the whole purpose of the H-1B. So it gives courts a lot more ability to be reasonable and come up with decisions that don't slavishly defer to a government's arbitrary decisions. And I think, that helps. Now, I say that, but it's important to remember, the government can screw up your life with the stroke of a pen, and that will take seconds. To fix it is going to take you a long time. So if the government does a stupid ruling or a stupid decision like they are prone to do, it takes months to fix that. And so that's frustrating, but at least there's, a light at the end of the tunnel, because the law has altered things to make it more favorable for you to challenge those stupid decisions.
Mm-hmm. Mm-hmm. Absolutely. So, are there any potential pitfalls or complications that H-1B families should be aware of, even within this ruling, in their favor?
So, I don't think there's any pitfalls that are out there. I think more than anything, it should concern the government that every single judge in the country now gets to look at the law fresh on its own, because the government is a big, unwieldy beast that doesn't move very quickly, and it doesn't really have the ability to adapt very well.
Mm-hmm.
And USCIS in particular cannot function by looking at how, Texas views the law versus Washington State versus New York, and they can't come up with different policies and procedures for each of those different locations. And I think that what that's going to do is it's going to make them far more careful in how they create rules, just so that they create consistency across the country. Because if they start getting rules invalidated in one location but not in another, it's going to be a real nightmare for them, and they're just not going to be able to function. So I'm hoping that it'll force them to be a little bit more reasonable in the way they create regulations and make decisions.
Okay. So, John, an additional question. So, in your experience, what are some of the most common legal challenges faced by H-1B families, and how does your firm assist in navigating these issues?
So one of the more disturbing trends that we see
Mhm.
is USCIS penalizing workers for errors or program violations of the employer. And what's frustrating about that is you as the H-1B worker have no control over anything during the petition process. USCIS, in fact, explicitly says that you have no role in this process. So you don't sign anything, you don't, give declarations to anything or the accuracy. Now, if the employer does something like not pay the full wage,
Mhm.
that's the employer's obligation to do. It's not your obligation to get paid the full wage, right? Because that's out of your control. But what USCIS is doing now is they're revoking visas, denying visas, and saying you're out of status if you're not getting paid the full wage. That is such a clear violation of the law that they typically cave in on that when they get sued. But the fact that they're doing it is frustrating. And I think, you have to be very careful. Anytime you see an employee getting penalized for something the employer did, that's a huge red flag. That's something that, you really need to be aggressive and push back on and not just assume that the government did it right because they didn't.
Okay, and let's also talk about, a little bit about the potential repercussions on American workers. So, John, critics of this ruling, like Safe Jobs USA, they argue that it harms American workers. So, what's your perspective on this claim? And does the data support the idea that American jobs are being displaced by foreign workers and their spouses?
See, the argument in Save Jobs that they're stealing jobs from U.S. workers is kind of a symptom of the greater problem. They don't understand math. And the American economy in general is just not producing enough people that understand math and can do critical thinking. So if you look at the graduation diplomas that are coming out of U.S. colleges, very few of them are going into the STEM programs, the jobs that we need to make the economy function at a high level. Far too many U.S. kids go to school, waste time and money to get degrees in things that don't matter and don't make them employable. And so if we want to stay on top of the game, we need people who are highly educated to fill those jobs. And if we're not doing it domestically, we're going to have to import. And so if we want to stay on the top of the world economy, we have to attract smart people. So it's frustrating to see, people that should be smart enough to look at the data and say, we don't have enough of these people graduating, therefore we need to import, smart workers. Instead, they're just basically racist and they just want to exclude anybody that's, not from a Northern European white country. So it really has nothing, in my opinion, to do with jobs. It has everything to do with, their nationalist take on what immigration policy should be like. They really want to keep it just to those Northern European countries if they could.
Okay. So if the American workers are thinking like that, and if the claim, of job displacement lacks strong evidence, so John, what can be done to address the concerns of American workers who feel threatened by the presence of H-1B workers and their spouses in the job market?
So, if you look at the difference between, like, say, the EB2 and the EB3 visa categories that have labor market tests, those categories were created back in the 50s and 60s when there was a real concern about protecting U.S. worker jobs. And so they instituted the labor market test. And it's a product of history that we're kind of stuck with. When they created the H-1B, Congress looked at all the data. This was all the way back in 1989 and 90. They looked at all the data and they realized we got a problem. We don't have enough people. And so they eliminated the labor market test from the H-1B program because they realized it wasn't necessary because we just didn't have the numbers that we needed, domestically for those jobs. So, the reality is I don't think most H-1B workers have to worry about that. It's only when they go to the EB2 and EB3 categories for their I-140s and 485s that they start having to worry about some of these arcane and convoluted rules dealing with the labor market tests.
Okay. And John, also, how does Wasden Immigration Litigation approach these delicate situations where the interest of American workers and foreign visa holders collide? And what legal strategies do you employ to balance these competing concerns?
To be completely honest, I haven't seen a legitimate case where a U.S. worker has been harmed by an H-1B worker. I see a lot of people who are what we call bottom feeders that file lawsuits and file claims against companies for immigration violations just so they can get settlements out of the companies. Litigation, unfortunately, is very expensive. And so companies do the math and they say, just to get rid of this case, we'll give them a check. And, it saves on attorney fees. And so you have a lot of these people that are filing claims with the government of discrimination just to get those checks, but there's really no discrimination in the system. It's all frivolous lawsuits claiming otherwise. So, I just really don't see U.S. workers being harmed. Okay. I look at all of my friends that have, STEM degrees, and they work in the IT industry. They came out of college and they were worth gold because, they were an American kid that had one of those rare degrees. And they move up very rapidly within those companies because there's so few people like them. There's just not any harm that they face from other smart, skilled, talented people coming into the economy and working. So I'm not worried about U.S. workers being harmed by highly educated people coming into the marketplace.
Wow, great. Thank you so much again for answering the question, John. Also, now, let's talk about global talent competition a bit. So, this ruling is also seen as a way to make the US more attractive to global talent. So, in your opinion, how does the US currently stand in the global competition for top tier talent? And what role does immigration policy play in this?
Yeah, so I think, obviously our industry is probably the most attractive in the world. Mm-hmm. But the problem that we have is structural, in that every other industrialized country, when you get a visa to work, your spouse also gets authorization to work. Right. And in the US, it's not the case. And so it's a huge disadvantage because, especially in the Indian community, you have two married people, both of which tend to be equally highly educated and ambitious and intelligent, and one of them doesn't want to just give up the hope at a career because their spouse has a visa. And so it's very easy for them to shop around and find countries where they can both work and they can both pursue a career. I think in the future, if the US wants to stay competitive, they're going to have to make some changes to the way they deal with spouses and make spouses, more flexible and more attractive to come to the U.S.
Okay. But do you think, because of this ruling, is there also a possibility of having a lot of scams? Because, just to get green cards, people also marry people living in the U.S. You must have seen cases like that, right, John? Right, John? So do you think more cases like that coming after this ruling?
I don't think so. I've been on quite a few cases dealing with marriage fraud, both within the government and outside the government. And I will say that marriage-based visas get probably more scrutiny than any other category out there. And, the amount of inquiry they go into for a marriage-based visa is really impressive, actually. And the amount of data that they research on the individuals and cross-reference information, it's very impressive. There are some serious structural safeguards in place to prevent marriage fraud. Mm-hmm. And if you do commit marriage fraud, you are forever banned from the US, and you have no chance of ever getting a waiver or anything. And so I think the likelihood of marriage fraud popping up as a very frequent thing is very, very unlikely.
Okay. Thank you so much again for answering the question, John. And also, do you think, are there other countries also that have more favorable policies for attracting skilled workers and their families? And if so, what lessons could the US learn from them?
So I would say Germany. Not only do they have amazing beer, but they have a very good immigration policy. I would say the Canadians as well. Mm-hmm. They look at the workers coming in as, valued guests, right? Mm-hmm. They're providing something that the country needs. And they don't, treat them as basically criminals that have to be inspected and scrutinized and suspicious of. And unfortunately, the way the U.S. immigration agencies have been trending is to view every single, applicant for a benefit as somehow, looking to commit fraud. And so their initial step in just about every application is, this is fraudulent, how is it fraudulent? As opposed to, all right, this is a very highly educated person, they fit their criteria, let's let them in. And so there has to be a mindset change within the government from everybody's committing fraud to, okay, we need these categories of people. Are they qualified? And that's a cultural problem that USCIS has, and hopefully in a new administration they put leadership in there that will clear that cultural problem out. But right now that's what we're stuck with.
Okay. Again, okay, thank you so much, John. And let's talk about future of H-1B visa program a bit. So, given the ongoing debates around the H-1B visa program, so what do you think is the future of this program? And are there any upcoming changes or challenges that applicants should be aware of?
So the biggest thing on the horizon, I would say, is there's the modernization of the H-1B regulation. Mm-hmm. USCIS proposed a new regulation dealing with H-1Bs, and they took comments from the public, and they were supposed to release the final rule in June. That's been since postponed until December. I would not be surprised if it gets postponed again in light of the Loper-Bright decision that overruled Chevron, because the things that they proposed to do in the new regulation, some of them explicitly contradict the statute and are dead on arrival when they get sued. But some of them are just really unreasonable and stupid and counterproductive to the purpose of the H-1B program. So if they go forward with all of those proposals, it's going to be something that gives attorneys like me a lot of ammunition to fight, because they're just they're acting very crazy. And so I think that modernization rule with all those limitations on the H-1B program might be watered down quite a bit in the final release, I'm hoping. So other than that, besides that modernization rule, USCIS has always created more rules through adjudication trends than they have through regulation. So, you start seeing new templates of decisions, new templates of RFEs and NOIDs and NOIRs. And that's the product of internal rulemaking in the agency that's kind of done in secret. You don't really know what the rules are until you start seeing them ask for information and asking you to prove things in the adjudication process. That's always a moving target. It's hard to say where that's going to go. But I think right now one of the things that we're seeing them really focus on is maintenance of status, and whether or not you can extend status or change status based on whether or not you maintain status. And the way they're interpreting maintenance of status, quite frankly, is unhinged, and it's causing people a lot of problems. People who have done really nothing wrong, and it's causing a lot of issues. So I think that's one of the potential harms that we're facing right now in the adjudication trends.
Okay. And how does Wasden Immigration Litigation position itself in the face of these changes? And what should H-1B applicants consider when seeking legal representation, especially, with the increasing complexities of immigration law?
Yeah, so when you're in the petition process, it's important to keep in mind what the law is and what the law actually requires. And when you see them, coming up with a new adjudication trend or a new theory of ways to change and alter the rules, it's important to push back on that and say, no, this is what the law requires. This is what we provided. We're eligible for the petition to be granted. And when you're in the litigation stage post-decision, it's important not to just take whatever USCIS said as true, because you're going into court and the court's going to decide what is true and what's not. And so, you have to look at every aspect of the decision and poke holes in it and say, this is wrong here, this is wrong there. And don't just say, oops, USCIS said no, so I guess I can't get it. You've got to think creatively and, hold the government accountable.
Okay. Thank you so much again for that great advice, John. And now, advice for affected families. So, John, also, what advice would you give to the H-1B visa holders and their spouses who are directly impacted by this ruling, and how should they navigate the complexities of their work permits and immigration status?
Yeah, so the H-4 is a great thing, and it's just getting better because its future is far more certain and predictable at this point. Anybody that can get an H-4, I would highly recommend getting the EAD, just because it gives you so many benefits and so much flexibility, and it doesn't have any other restrictions that the H-1B has. And it honestly makes you more employable than the H-1 does, because the H-1B has so many limitations. So it's a good time to be an H-4, and I think it's something that everybody should try and get if they can.
Okay. And one last question before I let you go, John. How does your firm assist clients in not just understanding, but also leveraging such rulings to their advantage? Could you share any success stories or maybe examples where your firm made a significant difference for an H-1B family?
It's a long list, frankly. So a lot of our cases recently, like I had mentioned earlier, have been focusing on the employee being held accountable for the employer's mistake or error. And we've been litigating these cases quite a bit, and most of these cases, when it hits the U.S. Attorney's office, the U.S. Attorney is defending the government in court. They look at it and they realize what USCIS is doing is crazy, because the way we present the arguments. And they lean on USCIS to fix things, and then we get a retraction of the denial and a new approval notice. And so those cases are rewarding because you're really dealing with somebody who's done nothing wrong, but is facing all the penalties and all the consequences. And so, unfortunately, that's a growing business area for us. I wish it weren't the case, because it puts people in a lot of stress and a lot of uncertainty for something that they didn't do wrong. But it's rewarding when we get those good outcomes for them.
Okay. All right. Thank you so much, John. It was a great episode. Thank you so much again for being here. I always love doing these shows with you. Your answers are always so insightful and so in-depth. So thank you so much again for a great episode.
Thanks for having me.
Thank you so much. And guys, if I hope the session was helpful to you as well. And if you want to reach out to Jonathan Wasden, you can give him a call at 844-592-7336. I would like to repeat the number, 844-592-7336. His email is john@wasden.law and his website is wasden.law. So don't forget to write an email to him, and also don't forget to check his website out. Thank you so much again, John. It was a great episode. Hoping to see you next week.
Thank you. Take care.
You too.